Recognized.
Thank you very much, Madam Speaker, and I want to begin by welcoming my good friend from Florida first to the Rules Committee and congratulate her on her first rule on the floor, and finally thank her quite sincerely for the distinguished service she rendered to our country when she was a member of the cabinet for former President Clinton. So it's wonderful to have you in the People's House. Well, Madam Speaker, we're here again. This time, the third and final title of the rules package for the 116th Congress. Title III authorizes the House to intervene, otherwise appear, or take any other steps in the case Texas versus the United States, lawsuit currently pending over the legality of the Affordable Care Act. In essence, if this passes, the House will be giving Speaker Pelosi the authority to intervene in this lawsuit on behalf of the entire House of Representatives. I spoke briefly about this matter during the debate on the overall rules package last week, and I'm sure my opposition to Title III will come as no surprise to my friends on the other side of the aisle. Today we have several speakers on our side from Ways and Means Committee, the Energy and Commerce Committee, all of whom are deeply familiar with these issues and who will be able to tackle this in more detail. But for now, I'll make just a few key points. First and foremost, it really isn't a surprise that the Democrats' poorly written health care law finds itself once again in legal trouble. The lawsuit this time arises from Texas, where 20 states have filed suit on the grounds that because there's no longer a tax penalty in place for failing to purchase health insurance under the individual mandate, and because there's no severability clause, the law itself is unconstitutional. Last month, the district court in Texas agreed with the states and struck down the Affordable Care Act. That ruling has been stayed pending appeal. This really should not have come as a surprise to the majority. At the time the Affordable Care Act was passed, many of us on the Republican side raised similar concerns. The act as drafted was too poorly written, too precariously balanced to stand up under its own weight. And the succeeding 9 years have caused those predictions to come to pass. Premiums have skyrocketed, insurers have fled the market, and for many Americans, the care they thought they were accessing under the Affordable Care Act has become anything but affordable. And before Republicans acted last Congress to repeal the tax penalty for the individual mandate, literally millions of taxpayers made the decision to pay that penalty instead of buying health insurance they could not afford. No matter what the outcome of this lawsuit will be, House Republicans have over and over again expressed their support for the protections for those with pre-existing conditions. And should the Texas decision be upheld, Republicans stand ready to work with Democrats to build an insurance system that protects people with pre-existing conditions, increases transparency and choice, and lowers the costs across the country. And that's exactly what we tried to do in the last Congress with the American Health Care Act, which we in the House proposed and passed as a solution to the broken law that is the Affordable Care Act. While it fell short in the Senate, its passage in the House clearly shows that Republicans were ready to take steps to fix this broken system. But rather than taking those steps today, Democrats are asking us to grant Speaker Pelosi a blank check to intervene in this lawsuit. Rather than allowing the states to continue to pursue this litigation, as is their right under the Constitution, Democrats want this House to intervene. But the majority has not said why intervention is necessary and why the House of Representatives must jump into this litigation against some of the states. Other states have already made the decision to intervene in support of the Affordable Care Act, rendering the intervention by this House unnecessary. At best, this proposal is a political exercise intended to allow the majority to reiterate their position on the Affordable Care Act. At worst, it's an attempt to pressure the courts. But either way, there's no real justification for doing what the majority wishes to do today. Madam Speaker, the best way for the majority to protect Americans and to protect access to health care is to pass a constitutionally sound law that's well considered, well structured, and that will result in lower premiums and better access to health insurance. It's not what they've proposed here, which is a wasteful expenditure of taxpayer dollars to defend the indefensible. With that, Madam Speaker, I urge opposition to the rule, and I reserve the balance of my time.